Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Today we are talking about the enforcement of a restraint of trade against a partner. Sometimes people speak about restraints of trade in respect of employees. Today we're talking about a restraint that's found in a partnership agreement. So we're going to be dealing with plaintiffs today. Those plaintiffs are seeking an interlocutory injunction. Essentially what they want to do is the plaintiffs want to stop the defendants from going after the clients of the plaintiff's firm. Let's get into the facts and figure it out together. Now, in the past, the plaintiffs, or some of the plaintiffs, and the defendants, or some of the defendants, entered into a partnership agreement together whereby they were going to operate an accounting firm. And defendant one, the first defendant, is a natural person, a real flesh and blood person, and they themselves are an expert accountant with expertise in a specific area, and so they're able to bring some expertise to their client base. The accounting firm ticks along for a while until the view is formed by our first defendant, our natural person, that they would like to resign, and that's in about May 2022. So in May 2022, we have defendant one saying to the plaintiffs or representatives of the plaintiffs, hey look, I'm going to resign. What happens then is a representative of the plaintiffs circulates an internal email that essentially says, right, at around 30 June 2022 or on 30 June 2022, defendant one is going to be leaving the partnership. Defendant one CC'd to that email and makes no objection to it at the time. Let me just plant that seed with you. Now, because this is what we call an interlocutory hearing, or partly because this is an interlocutory hearing, the evidence is not perfectly clear about what sort of happens from here. So forgive me if we're a little bit fuzzy. It's in part because of my terrible way of explaining things, but in part because the evidence before the court is not as extensive as it might be, with great respect. From about 30 June 2022, things become curious. The defendant one apparently remains part of the partnership, apparently within this kind of 26-week notice period for exiting the partnership. But things get a little bit fuzzy because before the end of December, firstly, the firm cuts off defendant one's IT access and stops paying fortnightly drawings. Those are fortnightly profits that partners can share, so that stops. And then we turn to January 2023, where this entity that the defendant has incorporated, that is actually the second defendant in these proceedings, appears to, or an entity with a name similar to it, appears to start doing stuff that is in competition with the original firm. Now, notwithstanding this, defendant one seems to represent that they remain a partner of the firm, and indeed represent that in writing in February 2023. So as time has passed, there's kind of this are you in or are you out, slightly fuzzy type scenario in the context as well where defendant one has gone and incorporated defendant two. Now, what really galvanizes the plaintiffs into action in this case is the plaintiffs start hearing from clients of the firms saying, oh hey, defendant one's reached out to us to perform this auditing work. What's going on? Sorry, I thought they were in partnership with you. What do you want us to do? What's the position? And so this kind of leads the plaintiffs to say, oh no, defendant one is off, poaching clients, speaking loosely, he's off in competition. And so that sort of is the grounds for these proceedings today. But just to further sort of further increase the cloudiness, at this stage, defendant one is still listed as a partner of the accounting firm on the accounting firm's website. And so we then come to the hearing, right? We've got the plaintiffs saying, we want an immediate injunction that pursuant to this partnership agreement, we've got to stop defendant one and defendant two from competing with us at all, or at least from poaching our clients, these sorts of things. So we turn to the partnership agreement. Now the partnership agreement includes a term that suggests that within 10 Ks and within 2 years of the end of their time at the partnership, that the departing partner, the exiting partner, is not going to be able to compete with the firm. And this is one of the terms that the plaintiffs rely upon. And what's interesting is that because this is a restraint of trade case relating to a partnership rather than an employee relationship, there's a little bit of a deeper examination of this clause that would actually seem to be quite abrupt and quite severe on its face. the short point is the court has a look at this clause and has a look at the broader nature of an accountancy firm and where you hold out the human face of the firm in order to engage with clients, and forms the view that there is indeed a prima facie case. On its face, it looks like there's an argument that the defendant one is in breach of this. And so that is enough to satisfy one of the criteria to seek one of these interlocutory injunctions. Now, there's another criteria that's satisfied, because remember, defendant 2 is just some company that the plaintiff has incorporated. Defendant 2 is not a party to the partnership agreement. But what the court finds, or the court has taken to law, which says that a covenanter, someone who's made a covenant, can't breach the covenant or can't escape the consequences of the covenant merely by incorporating a whole new entity to avoid their obligations. And so what the court says is, well, there's a prima facie case against both defendant 1 and defendant 2 in relation to the breaches of this partnership agreement. The next thing we turn to in relation to an interlocutory injunction is, what's the balance of convenience? So if you or I want to get immediate interlocutory injunctive relief, what we need to do is show there's a prima facie case. Well, we've already ticked that box, remember? Second thing we need to show is the balance of convenience favours granting this fairly violent form of relief. And the court says, in short, yes, it's justified. So the balance of convenience is met. The defendants say, hey, I'm under severe financial hardship. The plaintiffs say, hey, we're losing all these clients. And sort of in weighing up these two sorts of things, the court comes to the view that the balance of convenience favours the making of the injunction. And so the injunction is made. Defendant 1 being the partner, party to the partnership agreement, and defendant 2 being that entity that was incorporated by the partner, are prevented from engaging in this competing conduct, at least until the final hearing of the matter, and the injunction attaches to both of them. I hope that discussion assisted you, and I look forward to speaking again soon over another coffee and in respect of another case note. Cheers.